In business, we are confronted with both moral and legal questions. Those that choose to do the right thing are not always noticed. Those who choose to work outside the boundaries of law and ethics are well known. Welcome to BUL3130 Business Law and Ethics. Professor Thornton will be here momentarily.
All right, welcome to this week's lecture. We're going to be doing two lectures this week, one on Chapter 3, one on Chapter 4, since we are covering both of those in this module. So we're going to get right into it and cover a couple of things toward the end of this as far as the week goes. So Chapter 3 is all about civil dispute resolution. In our system and our legal system, our courts serve as our way that disputes between individuals, business individuals, however, are handled. Sometimes these are actual civil disputes between a governmental entity and an individual, or the other way around also. So we're going to cover the court system, jurisdiction, what it means, and what civil dispute resolution is, and then some alternative dispute resolution areas that you can go into to avoid actually going into the courtroom. If you're looking to do that, they're cheaper by far, and you can still get a good resolution out of them. All right, so the court system in and of itself is where our laws end up being brought into question. All right, so when we face a criminal charge, we go to court. When we face a civil tort, we can go to court with it. And what we do when we take these kind of matters to court is we're asking the court to look at the law as it's applied to our specific case and make a decision based upon that law and how it's presented. Now, sometimes we're looking to change that law and have a different outlook on it. Sometimes we are wanting that law applied to us the same as it was to a previous case. And in other times we may be looking to just defend against how a law may have been used at a prior time. So companies have to make decisions daily, and they do that based upon what their products are, what their manufacturing is, what type of investments they do, how they spend their money, what they're going to do. And inside of these decisions, they have to look at what is legal. Right? Everything that they do has to be based upon the legality of the issue. If they violate this in any way, they can be held accountable in court. And with what we're looking at with this chapter, we're looking at the litigation process, the process of them having to go to court to defend what they're doing against a wrong they committed in some way, or they're accused of committing against an individual, another business, in that type of setting. So when we look at this, we want to think about it as what has happened, why we've got to this point. So we're going to discuss the court system. How we get to that point, we'll discuss more when we actually talk about torts, and when we talk about criminal law, we'll discuss more about how we get to that point. But we're going to talk about the court system and how it works. First, we have the federal courts. Our federal courts, and in your chapters you would have read so far about certain areas of law that are specific to federal courts. But the federal courts are also broke down into what we have as district courts and courts of appeal. A district court is your main court for a specified area. So like in Florida, we're in the same general court area as Alabama and Georgia. So we're in the same area as them. Our courts and cases coming out of here go to there. It is 11, which is what that circuit is, or district is. The district courts are where your main trials happen. This is a general jurisdiction court. So whether it is a criminal charge that the federal government has brought against an individual, the U.S. government can bring criminal charges against individuals, or whether it is the appeals process. Once we've made it past the district court, we look at that in the Court of Appeals. That's our two levels that we have as far as those go. Once we come out of that and we've had a decision at the district court level, we're in the Court of Appeals. The Court of Appeal does not retry a case. They're looking for pieces of the case. They're examining the case based upon what it is being appealed under. Now, there are certain things that can be appealed. Not everything that happens in a case can be appealed in the way that maybe sometimes Hollywood may present it. So when we look at what an appeal is, we have to think about it on the basis of, was the individual's constitutional rights violated in some way in the previous court? That could be through how their representation was done, their attorneys. It could be done in how the evidence was presented. It could be based upon what the judge said to the jury. There are certain little things, and what we're looking for is some type of prejudicial error that happened within that district court that then would allow us to appeal that case to the appeals court and have them decide if that error caused the outcome of the case. If, barring that error, if we did not have that error happen, would the case have been different? And what the courts will look at is, okay, is there a basis for this? Do we have a reason why this could be appealed? So they look at the appeal and what the appeal is based on. Then they go back over the court records. They compare it. Now, in your book, you'll have cases that'll discuss what the appeals process is. It'll talk about the appeals process in there some. And in some of those cases, you'll see where the court will find for the appellate. They'll say this case is being remanded back to the lower court, district court, most of the time, circuit court. They'll say it's being remanded back to them for them to review it based upon this standard that we're telling them they have to look at it from. Or they will say that they uphold the ruling of the lower court, which means that the appeal is denied. Or they may even say that there's no basis for this appeal, so we're not even going to hear the case. So they can make a decision based upon that, and that's pretty much the parameters of where they make their decisions. They'll either send it back to the courts, they'll find that the appeal is good, or they'll send it back to the lower court for a reexamination. An appeals court can throw out a conviction based upon that and tell the court to retry the case. They're not saying that the person's innocent. They're just saying that the reason they were found guilty may have been prejudicial, so they need to retry the case. Or the reason they were found at fault was prejudicial, so the case needs to be retried. If we think about it from the tort system. Then we have them finding that, okay, well, this is good. They're not going to reverse it or modify it. They're just going to say that it is affirmed. We affirm their decision, and the case stops here unless there's a further appeal. The Supreme Court's the highest court. If you think about it as in the level of appeals, this is the highest point that a person can appeal to. It reviews decisions based out of those courts. It's not part of the appellate court system, but it is the highest court. And in most states, you have a Supreme Court, with the exception of a few. The one that stands out the most is New York. In New York State, the Supreme Court is actually their local court. It's just how they name their courts. In the state of Florida, though, we have a Supreme Court in the state of Florida, which is our highest court in our Florida court system before it would move into further appeals. And so when a case leaves the appellate level and goes to the Supreme Court, then it's up to that court to decide whether or not they want to hear it. The Supreme Court doesn't have to hear any case unless they see there's a reason for them to hear it, some reason why the justices should look at this case and make a decision based on it. Now you have some special courts, within the federal system. These are tax courts. These are federal claims courts. These are bankruptcy courts, courts of appeal for, of course, the federal circuits. These are the types of courts that you only access in the federal system. Bankruptcy is one that there's not a equivalent to it in the other areas where you have you can appeal tax questions in the state. If it's a state tax, you can appeal claims to the constitution of a state, but there's not a bankruptcy court within a state because bankruptcy is wholly a federal matter. And so you do not have that same court within the state systems. As far as legal systems are concerned, there are 56 of those legal systems within the U.S. They constitute the 50 states, the District of Columbia. You have your armed forces, military courts, your federal courts, and then you have 3 territorial systems that round out that 56 total. The territorial systems are based in territories of the U.S., of course. Judicial review is a very important part of what our courts do, especially the Supreme Court. Judicial review is kind of meant to be there along and along, but it wasn't until 3 presidents in that we made it to that point. And the case is Marbury v. Madison. Marbury v. Madison, just a real quick background on it. In Marbury v. Madison, you had an outgoing president that appointed a whole lot of federal judges, created a whole lot of federal judge seats, a whole lot of new seats for federal judges, sent out these appointments. And you have to remember, this is way back. This is the second president as he's outgoing, John Adams, as he's leaving office, sending these out. So they were going out by courier. They were, somebody on horseback taking these to, wherever they needed to go. The incoming president, Thomas Jefferson, decided that they were going to end these. No, we're not going to allow that, because it was 2 different parties. You had 2 different political ideologies, one outgoing, one incoming, and the incoming didn't want the courts to be full of an opposing political ideology, which is very similar to how it's happened throughout the history of the nation as far as that goes. And so when Jefferson came in, he and James Madison, put a stop to those appointees or appointments, and said that if they're not there, if they haven't taken to the bench yet, then they do not get to hold that office. Well, one of those appointees, Marbury said, well, no, I've been appointed. It's my right to have this seat and have this spot in the judicial system. And so he took it to court. Now, an interesting part about the case is that Chief Justice Marshall, who was the presiding justice over the Supreme Court at the time, was of the same party as Jefferson. So keep that in mind. He was of the same party as Jefferson, yet the court and Chief Justice Marshall wrote the opinion for the majority in the court, stated that Jefferson and Madison were wrong in what they did, and that those appointments to those seats could move forward and have those justices in place where they were appointed at. And so what this did was put a new standard in, and it's really and truly a new standard at this point, because it wasn't really pushed, but it was a new standard of the federal courts looking at the actions of a president or the actions of Congress and saying this does not go with the Constitution. It does not align with the Constitution. We're considering this unconstitutional, and therefore you cannot do this based upon what the Constitution says. The cases that go before the court now, and there are numerous cases about what happens in Congress, what happens in the executive branch, legislative branch, executive branch, the things that are happening there. There are current cases that are being heard by the court, by the Supreme Court, that have come up through the federal appeals system. Those cases are almost all based upon whether or not the act of the president or the act of Congress was constitutional. And so when they're doing that, they're asking the court to say yes or no. The court has to weigh this action against what the duties and what the powers of those other branches are. They have to weigh it based upon what the Constitution says those powers are. Is this a overreach of their power? Is one thing they look at. Do they look at, did the president overreach? Did Congress overreach here? So they look at the overreach. They want to know, does this line up with the Constitution as far as, is it violating someone's rights? If they're within their power to do it, does it violate someone's rights by the action of them doing it? The Constitution says things that they can do. But one thing that they have to take into account, especially the legislative side, the legislative branch, they make laws. That's part of what the Constitution says they do. They make laws. But when they're making these laws, what they have to look at, and what is so important, is they have to look at whether or not it's going to line up with the Constitution. And will that do that? Will it carry forward? Will this be something that they can move forward with without any type of question? Now, if it's an unpopular law, it's going to be questioned, but it still may be constitutional. The court is there, though, to make sure that it is in that sense. The court is there to make sure that when they look at it, if they hear the case, that everything lines up in the way it should. So there's not any overreach or overstep by those branches, and that would trample upon the rights of the citizens, which is what the Constitution is there to protect and what the courts are there to make sure is happening. So once again, how those circuits, what we talked about a second ago, the circuits of the federal court system. We're in Circuit 11 here in Florida. We're part of the circuit with Florida, Georgia, and Alabama. If you look at how the circuits are set up, it's a little strange. There are some very large circuits, some circuits with just, 3 states, some circuits with just a couple of states. They're all a little different, but that's based upon when those circuits were set up, how it worked for population and things along those lines. So if you look at 9 has California, the largest population in the country, along with, counting them up here, there's 2, 4, 6, 8, and territories. So 12 other states that are tied into California. All right, so 9 other states that are part of the same district or circuit as California, to where we're just Florida, Alabama, and Georgia. Florida may be, 3rd or 4th, depending upon how things are going in population, but Georgia and Alabama are kind of small, so we carried that. And it's just how it aligned at the time when the courts were being set up. Now let's talk about state courts real quick. A lot of it mirrors what we have with our federal court system as far as different levels. But there are a couple of things that we may have, a couple of levels that we have in state courts that may be a little different. We have what's called an inferior court. These may be county courts when you look at them, as opposed to a circuit court. Your county courts are sometimes the courts where if you get in a traffic accident, you have to go to court, or you get a speeding ticket, you have to go to court. Minor misdemeanor level cases may be there. Civil cases involving a small claims court would happen in your inferior courts. Pretrial hearings, those type of things would happen in inferior court. Not necessarily, anything major happening here. Then we have the trial courts, which within the state of Florida, we have circuits. Our state court system also has circuits. And, You have attorneys that work within those circuits and judges that work within those circuits who hear jurisdiction over large civil cases and any criminal case, any case that moves to the level of, say, a felony and would need to be heard, with a jury and things along those lines. A lot of times in inferior court, you don't see a lot of jury issues happening here. It's just something real small. You don't have a lot of juries involved with small claims court. Attorneys will be present in some of these, but a lot of times they're just there to make sure that the person who is standing in front of the judge has representation and understands what they're there for. To where when we get to trial courts, your attorneys are going to be present then. They're going to be the ones trying the case. They're going to be trying to get things to go the way that you want it to go, whichever side of it you may be on. States do have some special courts. Family court is a state matter probate court. When property is in question or being held for the questions to be resolved, would be handled in state court. Then states have jurisdiction over certain areas of state law also. We have appellate courts within the state system. Depending upon the state, it could be 1 or 2 levels. And of course, it always ends up going, if they make it through the appeals process, they go to the state Supreme Courts before they move on from there. So that's our court system. Now let's talk about what allows a court system to hear a case. And that's jurisdiction. That's the power or authority for a court to hear or decide a given case based upon what that court does. So a court of general jurisdiction means they hear general cases. Your criminal cases, things along those lines, are general cases. A subject matter jurisdiction court is one like in the federal system, bankruptcy courts. All they handle in bankruptcy court is a bankruptcy case. They handle hearings based upon someone filing bankruptcy when they're trying to decide what their payments would be, what debts are going to be, kind of set to the side, what's going to happen with that type of issue. On your state level, a subject matter jurisdiction would be a family court, one that decides. When we think about family court, a lot of times it automatically goes to divorce or custody hearings, but also adoptions take place in family court. So there is some good that comes out of the family court side also. So subject matter jurisdiction is going to be handling cases along those lines. Federal jurisdiction is anything that's an exclusive federal question, a question of the federal constitution, things like bankruptcy, of course, antitrust, patent, trademark, copyright, which is something we'll talk about later in the course when we get to intellectual property and those type of things. We'll discuss that pretty deep. Then concurrent federal jurisdiction is when both the federal and state courts have authority to hear a case, but the federal question arises under those things, and it does not involve exclusive federal jurisdiction. And then we have what's called diversity of citizenship. These are cases where you have citizens from different states. Diversity in this case means they're from a different state, so they're from a different area. One may be from Florida, one may be from Georgia, and the case involves damages and possible payouts of more than $75,000. So a car crash that doesn't result in major injuries, where it may be from Florida, maybe from Georgia, but they're just trying to get the car covered, maybe $30,000-$45,000, those type of things. That may not be one that we would go. Now, very seldom do civil cases when it ends up in something like that top out at $75,000. They're normally over that. You can imagine that this number, 75,000, was set at a much earlier time than where we are now. A subject matter jurisdiction for states, so we talked about it. State courts have exclusive jurisdiction over all matters to which federal power does not reach. And then jurisdiction over parties. This is in personam, against the person, refers to a court's power to adjudicate matters that are directed at a party. In other words, it's a jurisdiction where 1 or 2 forms of personal jurisdiction, with the other being in rem jurisdiction is the other one that we have there. Someone, when it has jurisdiction over the person, they're a citizen, They've done something within the borders of that state or that country. As far as the U.S. goes, they've committed a crime within the borders of the U.S. We would have jurisdiction over them unless there's, other extenuating circumstances. In REM jurisdiction is claims against is based against claims against property, things like liens, and when you have a loan, that's a lien that goes against your property. Attachment jurisdictions over the defendant's property to obtain payments not related to the property. In other words, being able to take other items that would cover the debt, basically, is what they're looking for. And then venue is the actual geographical area where the lawsuit should be brought. Most of the time, you want the venue to be local, and you would need it to be litigants that are from that area. Where we see this get skewed sometimes is in our federal system. People will shop, litigants will shop for courts. If they're more conservative, they may go to Circuit 5. Let's go back and look at this map real quick. So if they're more conservative and the case they're trying to get done is more conservative, they may look into Circuit 5, which is right now the most conservative court in the 5th District, is the most conservative court in the nation. 9, a little less conservative. They're quite a bit less conservative. Same way with, I believe it is 7. 7 is not quite as much. Same way with 6, but some of those are leaning more. And even District 9 has found some cases more toward the center than what they have in recent times. 5 is still extremely to what would be the right of an issue, as far as right or left or conservative or liberal. 5 is still very, very much a conservative court. So venue, when we talk about that, with what I just showed you, venue, if it happens in Texas, of course, that's the 5th Circuit. But what if it happens in Vermont, or it's a federal issue, and we want to question it? And we live in Florida, we live in Nevada, we live in, let's say, Washington State, and we may live in the Carolinas. All right. So we may all come together and we may all have a conservative mind, but none of us live in an extremely conservative court system or district or circuit. So what we need to do is find someone who is from the 5th Circuit who would agree to join us in that case. And they can then bring it in the 5th Circuit, where we may have a better chance of getting what we want accomplished. Now, this is where that catches once it moves through the appeal system. So in the appellate system, those cases will move through. Where the snag comes for a lot of these type of cases, no matter if they're which side of the political spectrum they're on, is when they get to, normally the Supreme Court is where this will catch them. The Supreme Court's going to look at all the appellate process and how it went. And the first thing they're going to want to do is, do they have standing? All right. So do they have standing to be able to do this? So what is standing? That means that by definition, you have to be in danger of suffering a loss if you do not win the case. You have to be affected in some way by the ruling if you do not win that case. In other words, if you're trying to get a law overturned or whatever, something changed, you have to be in a position where you would suffer a loss if it does not happen. What is going on a lot with a lot of these cases and the whole court shopping fiasco that has happened over the last few years, really and truly really ramped up in the last 12 years or so, is you may bring a party in and file a case in a certain area, but you do not have standing. They do not have the party you bring in to, bring this case for you. They do not have standing. The court would say, well, they're not going to lose anything. They're not hampered by this. They may disagree with it, but they're not going to be adversely affected. And so they can't bring the case because there's not going to be any adverse effect on them. And you would think that, okay, if it's a federal law or a federal issue, it's going to affect everyone. Well, sometimes they're for specific reasons, or specific spots. Maybe it's about national parks or things along those lines. You may be in a spot where that doesn't truly affect you. The court will look at it and say, okay, well, you're not going to suffer a loss. You're not going to suffer harm if you lose this case. You don't have standing in this case. A quick way to look at standing is the old way of saying that if you don't have a dog in the race. If you don't have a dog in the race, then you do not have any worry with the outcome of it. Then that is what the court is looking at. When we get to that point, then we have decided where we're at. Then the court will make a decision if they can hear it or not. That's how the court system kind of ties up and works. Now let's talk a little bit about the actual civil dispute resolution. Civil disputes enter the system by violation of rules of civil procedure. They follow the rules of civil procedure. They're designed to resolve disputes justly, promptly, and inexpensively. Okay. In a case, and this is going to be kind of the rundown of a case and how it goes, and I'm not going to kind of spend a lot of time. I'm just going to plow through these and we'll discuss them a little bit at the high points. Once we decide if we have a case, the way that it begins is what it's called the pleadings. The pleadings are statements made by normally a plaintiff. The plaintiff is going to bring a case. They're going to bring their complaint. A complaint has to be filed for the pleadings to begin. So once that is done, once we get to the point where we're beginning the pleadings process, then they will file it in the court. The complainant or the plaintiff will file it with the court. Once they file it with the court will then issue a summons, and in the summons, it'll be sent to the possible defendant for them to give an answer to these complaints. So the plaintiff and what they file will be a line for line of what the issues are. Who is at fault in their mind, what exactly happened, what they did to be at fault, their names and where they can be found, those type of things. Once the court sends that, then the defendant has to answer it. If they go through and they agree to everything, there's not a court case. They're just saying, yeah, I did do this. But when we get to the point of having a court case and they truly become a defendant is when they say, no, that didn't happen. And they give an answer to it. They answer each one of those in some way. And they'll have an answer that will reply to what has been done. And then in the reply, the plaintiff will have a further pleading as to the answers that the defendant gives. And this is the basis for that court case and how it begins. So when we made it to that point, we go into what's called pretrial procedure. Pretrial procedure is just where we look at the judge will look at what evidence they're going to allow, things will be brought in. There will be a time where the judge tries to encourage the parties to come to an agreement, a settlement, where it doesn't go into court. They'll try to get things handled in some other way. We'll look at the alternative dispute resolutions here in a few slides. They'll try to get things handled without it going to court. But if it doesn't work that way, then we go into the process of getting ready for court. Part of that is motions that'll be filed by the parties asking the judge to rule in favor of one party or the other by looking at the evidence, saying, Your Honor, the evidence just shows that there's no way they can win the case. Fine for us now. Those type of things. There's specific motions that they would handle. If the judge doesn't agree to those, judge doesn't honor any of those motions. If they deny them all, then we go into discovery. And this is where the parties will exchange information. Sounds counterintuitive, right? But it's where they exchange information, and they do this so that they can not have what is called a trial by surprise. So we don't want Hollywood to happen actually in our courtrooms. We don't want that last minute person walking in that saves the day. No, we want court to have a decorum to it, and we want it to flow a certain way. And that way, everyone has an understanding of what the outcome is going to be. We're going to hear the evidence, and the evidence is going to be known between the sides. The plaintiffs will let the defense know what evidence they have, what witnesses they're going to call, and the other way around. The things that are not divulged during discovery are anything that is attorney-client privilege, in that sense, where it is something that has to do specifically with that type of privilege, where the attorney and the client have had a conversation. That is not divulged, but anything as far as list of witnesses, evidence to be presented. The reason being is so that the other side can build their case based upon what they know is going to happen. It puts everybody on what should be a level or equitable playing field. It doesn't always work that way, but we try to get them to that point. In pretrial conference, the judge once again is going to try to get this, handled in some other way if it's at all possible. They want to simplify anything that's going on. Once again, the judge is going to look, okay, here's the evidence. If anything new is presented, can this be, admissible? Will we allow it? This is a spot for the attorneys to try to argue that evidence should not be admissible. If they think it's extremely prejudicial to their client, they could, ask that it not be admissible, those type of things. They may ask for a summary judgment, a final ruling by the judge in favor of one party based upon evidence disclosed in discovery. They look at what the other side has, and they're like, okay, our case is so strong, there's no way they're going to win. They file a motion with the judge for a summary judgment. The judge will either go with it or not. If they deny it, then we go to court. Once we set up this point, we go to what is called voir dire, or jury selection. In jury selection, where both sides will question jurors and decide if they want to keep those jurors. A couple of things that happen in this, you have what is called preemptory challenges, where the party can, the plaintiff can say, we do not want that, juror, Your Honor, we're going to use one of our preemptory challenges. Those are limited. They can't just go through and just wholesale say no, 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 no. There have to be some ways that they can say, we're going to get rid of this one. And then others, they can challenge it, but then it'll be a, back and forth between the two parties. Sometimes the parties will agree, no, that's not going to be a good juror for one reason or the other, whatever it may be. The defense may think that a juror is going to be prejudicial to them, and the plaintiffs may realize, okay, well, we keep that one. That may be a cause for them to appeal. So we're going to go ahead and go with them on this and get rid of that one. Those type of things. It's all a matter of them, a cat and mouse game, trying to seat a jury that they think will find for them and be more sympathetic to their side. The conduct of trial is when how the trial is conducted, not so much how they're acting, but how the trial is conducted, the conduct of the trial. This is when we have opening statements by the attorneys, when they question witnesses and then cross-examine those witnesses, and then closing arguments. That could be weeks, could be just a few hours, depending upon the trial and what all is being presented. The thing to recognize there is that you have an opening statement, which is a statement. They're going to say, this is what the case we plan to lay out, what we're planning to do without divulging everything. And then they have a closing argument. This is their last time to really try to use everything that they have within them to get the jury to find for their client, is what they're looking at there. Once we get to that point, they can file a motion for a directed verdict. This is a ruling by the judge in favor of one party based upon what they have seen at trial. Then if that doesn't happen, the judge gives the jury instructions based upon the case. The instructions, some of those are similar throughout. They're going to be the same in each type of case, but then some are specific to the case. This is the law that you're applying here. This is what you're looking at. This you do not consider, this you do not consider, this you do not consider. Okay, those type of things. The judge wants that to happen. Once that goes in, the jury will deliberate and come out with a verdict, and the verdict will either be guilt or innocence, or in the case of a civil trial, liable or not liable. And then they can come out and say, well, we couldn't come to an answer. We couldn't figure this one out, and be what's considered a hung jury. Motions, of course, can be filed to challenge it. They can ask the judge to rule the opposite way. It's a motion of judgment was notwithstanding the verdict that can be filed. If all that goes through, the side that loses is happy, they can then enter the appeals courts and go through all that. In a civil case, that there's damages, there can be enforcement done through a writ of execution. They can have the sheriff in the area seize the property, and wage garnishment be done through the courts, whatever it may be, to have the dispute handled and the damages be paid. Now, real quick, talk about alternative dispute resolution. Yeah, there's just a couple of slides here. And I'm only going to go over 3 of these because one of those is real similar. That fourth one, conciliation, is pretty similar to mediation. But I'm going to go over these backwards so that we kind of have an understanding of the progression up. Negotiation is real simple. It's the parties come together, just the parties, and the parties are discussing and trying to come to a resolution without any outside interference, without any outside influence. They're trying to meet out and decide what is going to be the outcome of their disagreement or whatever it may be. That involves just the parties and nobody else. Keep that in mind. The negotiation is the parties only. All right. Mediation is when we bring in a third party. This is a neutral third party that does not have any legal power to make a binding decision or bring a resolution of this. They are there to simply do exactly what their name is: mediate conversation between the parties. Their sole purpose is to bring the parties together and to get them to talk. Normally, when negotiations fail, mediation is that next step so that we can get a party in there, somebody who hopefully can get us to the point to where we get to a resolution. Conciliation went backwards here. Conciliation is really close to the same thing. It's just that there's not as much interaction as you would with the mediator. And then you get into arbitration. The arbitration changes drastically from mediation. You now have a third party, of course, that's neutral, but this is going to be the third party is going to be a subject matter expert in the case. They're going to know about this type of law, and they're going to be able to make a binding decision based upon what the parties present to them. They're not there anymore to get the parties to decide. They're in that position to make a decision that they then submit to the court for the judge to sign off on if it's approved by the court. Their decision is binding. It's legally binding. And the courts, when the court signs off on it, it's the same as if they had gone through the whole process that we talked about earlier with the court system, if they had gone through the whole process and got to a verdict. So it serves the same purpose, but it is a lot less expensive to go through arbitration and mediation than it is to spend time in court. This last little piece is just a table that you can look over. It's on this PowerPoint, of course, and then it's also in your book. All right, so that's going to wind us up on civil disputes and that process. If you have any questions on that, please reach out to me. I'll get this one posted, and I'll also post today at some point. It may be later on this evening or at some point today, I'll be posting the one for Chapter 4. so that you have it in place and you can look over it. And until that video, stay safe and study hard.